My name's Jerry Maatman. I'm a partner at Duane Morris. I run the class action group there. My colleague Jen Riley, who's vice chair of the group. And what we wanted to talk about basically was the state of the class action world. For 19 years, we've put together an analysis of cases. And what we do is every morning check for every ruling in all 50 states and all federal courts and download those rulings. Do the same with settlements and settlement approval orders. And do the same with class actions that are filed in all areas of law. And what we do is we put them into a database and use that to crunch the data and try to come up with trends and analyses as to what is going on in the world. And on the website for this conference, you can download that book. It's an e-book. It's free. It's about 550 pages or so, loaded with charts, graphs, analysis, and descriptions of particular cases. And so this has been cited in Supreme Court briefs. Very proud of that. We run it off a class action website that we have at our firm. So by way of background, Jen comes to this as a thought leader in this particular area. She's handled class actions throughout the United States. She has a focus. It's on employment-related, ERISA, wage and hour, civil rights, Americans with Disabilities Act, Title VII, EEOC cases, and has handled a couple of the biggest cases both in California and New York. Our docket is about 50% California, 50% the rest of the world, so to speak. And when we do our daily downloads of cases, a good 50% of them are in California. So one of the things we're going to talk about today are what we term as epicenters, both for filings and for rulings, and what has occurred in those epicenters over the last year and what we would prognosticate occurring in 2023. So what we wanted to talk about today in this particular slides are settlement activity, the Holy Grail in the class action area, what occurred in 2022 and what we see happening in 2023. And then a very interesting set of analytics on what we call class action certification conversion rates. Number of cases that are filed, number of cases that are certified, and then what happens with those certified cases. Talk a little bit about attorney's fees awards, and 2022 was a year unlike any other in that space. And then we'd like to end on kind of what we saw as the key trends in class action litigation in 2022 and what we expect in 2023 in terms of an overview of this particular area. So, without further ado, we wanted to start with the settlements. And there's an entire chapter in our 550-page book on the settlements. And I think that one way to think about the settlements is 2022 was unlike any other year other than maybe 25 years ago when big tobacco cases were settled. When you add up all the monetary values of the settlements in 2022, you're over $65 billion, and there are $14 billion settlements. Here are the top 10 that are listed. And the book that we do has 23 chapters, of course Rule 23, but 23 substantive areas of law that we look at. And these settlements pull from all of those particular areas, but the driving force for settlement money were the opioid settlements in that particular industry that started happening 2 years ago and crescendoed last year, though there have already been a few this year. But estimates are in that particular space over the 5-year, 6-year period of time when there's the workout of all these cases, it's estimated that those settlements will be over $100 billion. So definite redistribution of wealth in terms of what we're talking about in this particular space. Jen, what about substantive law areas?
Thanks, Jerry. So as Jerry mentioned, although the opioid settlements fueled that huge number in the products liability and mass tort area,
That's really the beginning of the story in terms of the overall settlements for 2022. We saw enormous settlement numbers in other areas, other substantive areas of class action litigation, with the top 10 settlements in 5 of the areas, as reflected on the slide, exceeding the $1 billion mark. Those areas include consumer fraud, antitrust, securities fraud, as well as civil rights cases. The top 10 settlements in privacy and data breach as well climbed toward that $1 billion mark with numbers in excess of 700 million. Because success tends to lead to copycats, in this area we expect to see more filings and activities in some of these core substantive areas as they remain white-hot areas of focus for 2023.
Jen, when you studied these areas, were there any areas that were lower than in years before as opposed to going up that would signal a trend in these particular spaces?
Yeah, great question, Carrie. So as you can see from the slide, a few of the areas are on the lower side, comparatively speaking, from what we've seen in other years, including EEOC-initiated government enforcement litigation, which tends to be driven somewhat by the administration with a lagging lag behind the change relative to the Republican and Democratic control of the government.
So what will 2023 bring? Well, I've already seen it in mediations that I'm involved in as a class action defense lawyer, with plaintiffs' lawyers referring to settlements or the going rate to settle cases in 2022, and referring, as we all know, to kind of social inflation factors that are out there in the economy and in the courthouse in terms of the value of particular cases. I teach at Northwestern University School of Law in the trial practice course, and in picking juries, we've had quite a bit of research, and there's quite the notion now that juries are angry post-pandemic, and juries are rendering these nuclear verdicts in single plaintiff cases. We had one case, at least Jen and I practice in both California, Chicago, and New York, where we had one jury trial class action case in Illinois in November involving the Burlington Northern Railroad, and it was a privacy case in Illinois, the Biometric Information Privacy Act, and a week-long trial, $245 million verdict, full value of whatever the plaintiffs could have secured, no mitigation in terms of the defense arguments, and by all measures just a massive verdict now up on appeal in the Second Circuit. So I'd expect the plaintiffs' bar to be pushing for higher values in 2023 and pivoting off the results of 2022. Now we wanted to move over to class action certification rates, and we have data going back to 2003 in this particular area. And what we've done is we've searched and compiled certification rates by substantive law area, and in the book that's available on the website, you'll see it by circuit, you'll see it by state, and you'll draw the conclusion that class action litigation, at least when it comes to certification, is not unlike buying a house. Location, location, location being everything, and explains why there are epicenters of class action litigation on the coast, in the Second Circuit, and in the Ninth Circuit. So as you see here, there's a bit of a mixed bag depending on what particular area you're in, that some cases or some case theories in class actions are readily amenable to class certification. And in the Warren area, where everyone is laid off without notice, or in the securities fraud area, where everyone is impacted by the same alleged fraud, the certification rates tend to be, very high. Lower when it comes to RICO or antitrust, sometimes with data breach cases where it's more of a jump ball. But I think that at least one area that's very, very interesting, and where there's an ongoing debate in the case law, is in the Fifth Circuit when it comes to wage and hour cases. And Jen, you studied that, briefed it, argued it in courts. Why don't you explain a little bit of the background there?
Sure. So this relates to the standard for collective action certification under the FLSA, or the Fair Labor Standards Act. Traditionally, courts have applied a two-step approach, the first step being a conditional certification ruling, and the second step being a consideration of decertification. In the Fifth Circuit, over the past 2 years, that has been questioned, upended, revised, and this Fifth Circuit has said this is something that's really not driven by the statute, and it's something that's not really required. So let's take a more factual look at this from the outset, see whether people are in fact similarly situated after some discovery, and we'll do more of a one-tier approach with a factual record as to whether people are similarly situated in this. The case should be amenable to a collective action certification.
So in the wage and hour area, there is a first stage conditional certification, and then after discovery outside of the Fifth Circuit, a second stage decertification process. And at least over the last 5 years, plaintiffs have won 4/5, 80% of those cases. And so the employment area throws off a good chunk of the total aggregate class action filings that are brought. Wage and hour probably constitutes 90% of those employment-related filings. So at least in that particular space, the plaintiffs' bar are doing very, very well, and doing so without having to hire an expert, doing so with simply filing a declaration or two along with their motion for conditional certification, doing it early on in the litigation in the first 30 to 60 days, and in one particular space in the wage and hour area, basically the plaintiffs' attorneys have been earning about $500 million every year for the last 10 years in terms of settlements, in terms of the ease of certifying their cases. And so the Fifth Circuit decision is now being reviewed by the Sixth Circuit. The Eastern District of Virginia recently came around and adopted the Fifth Circuit view. And if it does, there'll be a lot less certification activity. It'll take longer. It'll look a little bit more like Rule 23. So that would be one area we think to look at in 2023. We mentioned attorney's fees before and how 2022 was unlike any other area or any other year in this particular area. And we saw 5 attorney's fees awards in class actions that were over $500 million, 7 over $250 million, 9 over $175 million, and at least the top 10 roughly at $100 million. Again, eye-popping numbers that hadn't seen in decades in terms of all this aggregate. And so I don't think 2023 can replicate this. You'll see some big ones, but in terms of the aggregate amount, I would think that the settlements would be down a bit in terms of attorney's fee awards. The area we wanted to focus on to end our presentation would be the difficult job of how do you pick out the key trends of 2022. And so what we tried to do was pick out what we thought were 10 trends that were noteworthy in 2022, and then our next slide talks about predictions for 2023. So the first one, we talked about the unprecedented redistribution of wealth in terms of settlements and the settlement numbers. Jen, how about number 2 in terms of Supreme Court rulings and how it defined the landscape?
Thanks, Jerry. So the U.S. Supreme Court has continued to define and shift the playing field in the class action space over the past several years. This past year was no exception. The Supreme Court issued 3 rulings that have a potentially substantial impact in terms of the class action litigation. All 3 of those over the past year, consistent with recent past, related to the arbitration defense. So the arbitration defense to class action litigation has emerged as probably one of the most effective tools to combat class actions. This means that a company or a defendant can, right out of the gate, file a motion to compel arbitration and cut the class action off right from the get-go if the individual bringing the suit has signed or otherwise agreed to an arbitration agreement where he or she committed to bringing his or her claims in arbitration on an individual basis. So this past year, the Supreme Court has waded into the arbitration space again and issued 3 decisions. One was a door closer in terms of expanding the arbitration defense, closing the door to the courthouse. In Viking River versus Moriana, the Supreme Court cut off California's attempt to immunize PAGA actions. Those are Private Attorney General Act suits. Cut off California's attempt to immunize those from arbitration and essentially held that the FAA, or the Federal Arbitration Act, preempts California's effort to prevent PAGA claims from being divided into their individual and representative components, such that the individual component, the PAGA claim or the claim for PAGA penalties of the person bringing the suit, can be diverted into arbitration. There were also, for the first time, we've seen so far two decisions that really seem to weaken the arbitration defense. One of those was Southwest Airlines versus Saxon, where the court broadened the transportation worker exemption, thereby narrowing scope and effect of the FAA. And in the second, Oregon versus Sundance, the Supreme Court broadened the opportunity for waiver of the arbitration defense, so potentially curtailing it from that standpoint as well. Let me go on to the next trend here. So those rulings there, I'm looking at number 3 now, setbacks for the arbitration defense. Those rulings really contributed to the first weakening we've seen of the arbitration defense in the past several years. There was also a weakening on the legislative front in that Congress passed and the President signed the Ending Forced Arbitration of Sexual Harassment and Sexual Assault cases, which now says that the plaintiff in one of those cases, even if that plaintiff has signed an arbitration agreement with a class or collective action waiver, can choose to disregard that and bring a suit in court anyway in cases involving sexual assault or sexual harassment. Fourth trend, class certification conversion rates. So we touched on this one earlier. I'll just note that overall, across all substantive areas of class action litigation, the plaintiffs achieved an amazingly high success rate in the neighborhood of 75%. Over the past year, courts issued about 360 rulings on motions to certify or to deny class certification. That's about 1 per day. Plaintiffs were successful in 268 of those rulings. So that's about 1 per work day plus about 8 Saturdays. So that reflects the overall immensely successful rate at which the plaintiffs have certified classes and maintained certification over the past year. Jared, do you want to talk about government enforcement litigation?
Sure. Before I go there, I saw the headline in Class Action Law 360 this morning, and it was on Friday's ruling by the First Circuit applying the Saxon case and denying enforcement of a motion to compel arbitration in a class action involving delivery drivers for a bakery company on the theory that the products were crossing state lines and that those class of workers were carved out of the Federal Arbitration Act, in essence taking Saxon one step farther. So I think that the setbacks to the arbitration defense are continuing in 2023, and so that kind of bulletproof defense starting to show some kinks in the armor. Government enforcement litigation, those cases walk and quack like a duck in terms of looking like class actions when, for instance, the EEOC or the Department of Labor, the Department of Justice bring cases. And I think that one area where litigation was down was in that space, and I attribute that to the Biden administration still working out the leadership roles in many of those agencies, some of those agencies not having their budgets approved, not having policymakers or decision makers in place to be able to execute on the Biden administration's policies, and at least in the labor and employment-related space, the number of DOL and EEOC enforcement actions was way down. Settlements were a little bit up, but those were with respect to cases that were in the pipeline actually from the Trump administration. And believe it or not, there were more cases brought by those agencies during the Trump administration than there were during the Biden administration, but I would expect in 2023, especially on the labor and employment front, with the Senate approving some of those decision makers and policy makers at those agencies, 2023, there'll in essence be a new sheriff in town, and there'll be more of those cases coming down the pipe. What about privacy? That, from all accounts, Jen, seems to be the hottest of all the areas of class action litigation.
Absolutely, Jerry. So privacy litigation, particularly litigation in the class action space, has emerged as one of the hottest areas where we're seeing the largest amount of growth. And let me comment on two areas of privacy litigation in particular. So the Illinois BIPA, or the Biometric Information Privacy Act, has really prompted a swell of lawsuit filings from about 2018 forward. The stiff statutory penalties under that statute, combined with fee shifting, has really fueled litigation. Illinois, in that sense, is providing us somewhat of a crystal ball look into what we might see throughout the country as other states continue to consider similar legislation in the privacy area. As to the second area, even though these aren't new statutes, plaintiffs have been continually finding creative ways to apply old statutes. So wiretapping, eavesdropping laws have been on the books in many states for decades, and the plaintiffs' class action bar has been invoking these laws that prohibit the interception or the recording or the surveillance of electronic communications to apply them to technologies that track user interaction and activity on web pages. So these laws are in California, Pennsylvania, Massachusetts, Florida, and they're sort of being resurrected and applied to these new technologies that they were probably never really intended to cover. So given that the potential for penalties in this area, with every click, with every collection or scan, you can see the snowball effect, the potential snowball effect of those penalties, making this an area of tremendous growth in terms of its activity in the class action space. Jerry, do you want to talk about data protection?
Sure. So in the privacy area, when we do the daily downloads of class actions and see where the filings are, there are at least 20 privacy class actions every morning that show up in California, and they're from San Diego north through San Francisco. And so it used to be PAGO or wage and hour cases were the #1 filings in the state of California. I think that's been replaced by privacy statutes, and California's privacy protection law was amended and went into effect on January 1, 2023. So I would expect in this year, 2023, probably privacy will take its spot as the #1 sort of filing that's made across the United States. In terms of data protection, we certainly see that following any data breach, there seems to be inevitably a lawsuit that follows within a few weeks to a month. But as that slide on conversion rate showed, this is one area where the courts are in essence looking at those motions to certify a class, and it's more like a jump ball around 50%, and that's because of the ongoing debate in the federal courts over standing and the TransUnion versus Ramirez case, and just what an actual injury in fact means in federal court, and what it means to be a victim of a data breach, and whether or not there is any standing. And so defendants have probably kicked the tires in the standing defense in the most profound way in the data breach space, and are winning at least half of those motions. And so I think there's been a rapid development of standing concepts in the data breach area because of just the way in which those cases move forward. We're going to talk about standing and uninjured class members and personal jurisdiction in the next slide. But Jen, the 10th trend on PAGA or private attorney general actions in the state of California?
So as I mentioned, as the prevalence of arbitration agreements grew as a mechanism to cut off class actions from the get-go, the plaintiff's class action bar continued to look for workarounds. How do we get around these arbitration agreements and maintain these class actions? And PAGA, or Private Attorney General Act of California, really emerged as the front runner in terms of one of the most popular workarounds for arbitration. With the California Supreme Court's Estanian decision in 2014, the number of PAGA notices skyrocketed. So we're talking about single-digit PAGA numbers from the beginning of the 2000s have grown now to about 6,500 PAGA notices per year, making it a very popular workaround to arbitration. This past year, though, the Supreme Court, as I mentioned, in Viking River versus Moriana, really drove a dagger into the heart of PAGA as a workaround by holding that individual PAGA claims can now be separated and broken off and sent to arbitration. What happens to the remaining portion of the PAGA claim in terms of the representative portion remains to be seen. The Supreme Court said the plaintiff, after his individual arbitration claim is directed to arbitration, lacks standing to maintain the representative claims. But the California Supreme Court is set to revisit that, and we should know later this year whether PAGA claims are going to remain the headache that they are today for corporate America, or whether the Supreme Court was right in terms of a PAGA individual lacking standing.
I know that Jen, you and I have quite a robust docket in the state of California, and it's amazing to me the number of trial court judges in the state of California that have said the Supreme Court of the United States got it wrong when it came to Viking River and interpreting our statute and our PAGA and what it means, and the amount of trial court judges there who basically say, I really don't care what the U.S. Supreme Court held. That's in Washington. We're here in San Jose, California, and we interpret the statute differently. So it's just a ton of litigation and appeals in that particular space. So what about 2023? We picked out 3 areas that percolated in 2022, but seemed to us to be very important threshold issues, 2 of which at least, the top and the bottom bullets, are going to impact class certification arguments around the United States. Jen, you want to talk about jurisdictional issues?
Sure, Jerry. So as Jerry mentioned earlier, location is all important in terms of class action litigation, and then we see different filing numbers corresponding to different rates of success in different areas. Well, corporate defendants have built up their own defenses to forum shopping, one of which depends on personal jurisdiction. So not an arcane concept from law school anymore. The Supreme Court has really breathed some new life into the personal jurisdiction defense over the past 8 years. The Supreme Court confined general jurisdiction now to a corporation's place of incorporation and principal place of business, and in 2017 issued a ruling in a case called Bristol-Myers Squibb versus Superior Court that also potentially curtails specific jurisdiction. So even though that was a mass action, and the Supreme Court said that the court needs to have a basis to exercise personal jurisdiction over the claim of each plaintiff. So again, that was a mass action. Results in terms of whether that applies and translates over to the class action space have been mixed. Defendants haven't fared very well in terms of applying it to class litigation, but have actually done a great job in terms of applying it to collective actions. And courts have started to say now that each member of a collective action, the court has to have a basis to exercise personal jurisdiction over the claim of each member of a collective action, meaning that those claims are now going to be cut off to the extent that that decision takes hold. Those claims are going to be cut off and made into statewide claims instead of national claims, except where a corporation is headquartered or incorporated. So far, the 6th Circuit, the 8th Circuit, and now this year the 3rd Circuit have agreed with that, with the 1st Circuit taking the opposite approach. So that's another defense where we're likely to see some additional activity in the upcoming year, and then some potential resolution by the Supreme Court.
Another area where we're seeing is what are called service awards. Obviously, when you settle a class action, the named plaintiff or plaintiffs can receive a service award for their participation in the case, sitting for a deposition, attending the mediation if they happen to have done that. And those payments are modest, anywhere from $2,500, $7,500, $12,500. But in the 11th Circuit, those are illegal. Based on a decision a few years ago, that case or that issue was appealed to the U.S. Supreme Court and cert was denied. And so the workaround that I've seen or that we've effectuated in the 11th Circuit is to term it or call it something else. But the 11th Circuit decision is very interesting insofar as it gains support for its view that service awards should not be allowed in a class action setting by citing two cases that were decided by the U.S. Supreme Court before 1875. So they're old chestnuts of law. Other courts, other judges in other areas of the country have rejected that. So whether or not it's important enough to get to the Supreme Court remains to be seen, but it also indicates that your settlement approach needs to be flexible and adaptable to the circuit you're in, and obviously to figure out a way to get around that in the 11th Circuit. The last area I think is a very important one, and one that Jen and I received some success in California on earlier this year in preventing the certification of the class because of the appearance of what are called uninjured class members and what that means to the certification process.
Right, Jerry. So this is a fascinating issue that I think is going to continue to get a lot of attention. The question is, what happens when you have a class with uninjured members? So everyone agrees that a court doesn't have power or authority to award relief to someone who didn't suffer an injury. But what happens when members of a class seeking monetary damages haven't been injured? Courts have taken different approaches and continue to grapple with this. Is it such that a class can't be certified because the court can't possibly award class-wide relief? Is it that the plaintiff has to demonstrate that every member of a class actually suffered injury? Or does the plaintiff have to demonstrate that those individuals who haven't suffered injury have been excluded? Or is the plaintiff's injury in his or her standing alone sufficient to support class certification? So different courts have taken different approaches on this issue, but it's a potentially very powerful tool for the defense. If a defendant can prevent class certification every time it can show that one or more individuals are injured, that is a potentially very powerful defense tool. So I expect to see additional litigation on this defense, especially in the upcoming year.
I know the Ninth Circuit's decision in the Bumblebee antitrust case was the main case that received most of the news, went up to the Supreme Court, and many people surprised when certiorari was denied on that particular case, but I think that this case will find its way up to the Supreme Court in the next year or two. So that's our tour of the class action world. A lot of decisions in a very short period of time to set the die for the discussion today. So thanks very much for allowing us to join you here today.